Okay, Chapter 9, Part 2. We left off with this slide, so now we're going to go to the next one. And we're going to talk now about social media. So social media is raising a lot of issues. If you pay attention to the news, you know that Congress is frequently calling, I can't think of his name, the owner of Facebook and other similar social media to testify because of their concerns about a lot of things that are happening with social media, particularly, I guess, from the political perspective, the ability to promote false information through Facebook and other social media. And that creates a lot of questions between First Amendment, the obligation of a platform like Facebook, etc. So this is going to be a very growing area as far as the law is concerned. I suspect that we may see some new laws in this area. So far, Congress has walked softly in this area, hoping that the industry would regulate itself, so to speak. Part of that may be their concern about questions about the ability to pass laws that would be constitutional and not infringe on free speech. But at any rate, that's a growing area. So social media provides a means to create, share, and exchange ideas and comments via the internet. Some of the legal issues emerging. Social media posts are routinely included in discovery litigation because they can provide damaging information that establishes a person's intent or what she or he knew at a particular time. Okay, so lawyers now in the discovery process are often asking the other side to provide their access to their digital storage devices, whether it be access to a hard drive or a cloud or a jump drive, and then searching their media for things that might be helpful. So we don't need to get into all the examples of this. There's millions of them. But typically, for example, in a divorce case where there might be an allegation of adultery, people will look for people having affairs or relationships through the internet, or for damaging information there. Social media posts have been used to invalidate settlement agreements that contain confidentiality clauses. So if you have a clause in your settlement agreement that says you're not going to tell anybody about anything that's in that agreement, and then you do so through social media, it can be set aside by the court as violating that agreement. Law enforcement uses it to detect crimes and prosecute criminals. Federal regulators use it in their investigations into illegal activities. And the last one, which is particularly important, I think, to young folks in college who are going to be entering or are in the workforce, the use of it by employers, both in the hiring process and in the workplace. So the law has basically ruled that if you're using a computer that belongs to your employer has complete access to what's on that computer. So if you're taking lunchtime and you're doing things that perhaps either are illegal or are in conflict with your boss's business or otherwise violate perhaps your contract with your employer, you can be fired, and there's nothing wrong with the employer screening those activities. And another thing that employers do is to screen employees through social media before they hire them. So many employers will look at your Facebook page and any other social media to see what kind of person you are. Are you doing anything illegal? Are you doing anything that would be not in the company's best interest or not make you a good fit for the company? So years ago, I guess about 10 years ago, when my son graduated college, he asked me if I had any advice for him. And one of the first things I told him was clean up your social media. And another thing that is important is your message on your answer phone or whatever you use to get messages. Make it more professional. One of the things that used to bug me a lot when I would hire people, but not just hiring people, but in general, when I might call a student or another attorney. Well, I don't think I ever had an attorney do this, but some people, when the answer device answers, they play 20 seconds or 30 seconds of their favorite song. Well, that may not be my favorite song, and even if it is, I may not want to lose that 20 or 30 seconds to have to wait to leave a message. So I implore you not to do that in the world where people check on things like that. Okay. The Electronic Communications Privacy Act amended federal wiretapping law to cover electronic forms of communication. It prohibits the intentional interception of any wire, oral, or electronic communication. It also prohibits the intentional disclosure or use of information obtained through interception. Some of the exclusions are ones that are employer authorized in the ordinary course of business. Okay. Stored Communications Act, the SCA, prohibits intentional and unauthorized access to stored electronic communications. Prevents providers of communication services from divulging private communications to certain entities and individuals. Protection with regard to passwords. Some employers and schools will get social media passwords from applicants to see if their accounts include controversial postings. A majority of U.S. states have enacted legislation to protect individuals from having to disclose their social media passwords. Okay, now here's an important area. I think I mentioned this before. Important for a couple reasons. One is because you don't want to get caught in a lawsuit where you have to pay over money in damages. But more importantly, I think, is the fact that the electronic world has offered greater opportunities for defamation. And this is particularly true because a lot of people who get onto social media don't even think that what they say might give rise to a lawsuit. I think what goes on is if you have two people in a room and they're chatting about some friends and they say some things that are false and derogatory, that stuff has been going on for thousands of years. And most of the time we don't have any concern about that because those two people are going to keep it quiet, and also because it's only two people, it's not defamation. Remember, defamation has to be, no, it is defamation because it's a third, you're communicating it to a third party. But nevertheless, the problem is that when you go on social media, you're exposing it to a lot more people. Online defamation is can be a cyber tort, and it's one of the most common activities. We first have to identify the author of the statement that might be defamatory. So anonymity can pose a problem. ISPs, your providers, can only disclose personal information about its customers when ordered to do so by a court. So presumably, if you've been defamed, you may file a lawsuit against somebody claiming that they defamed you, and you may try and serve the ISP with a subpoena to produce evidence that would help you know who the person was that made that communication. All right, so what are the liabilities of the Internet service provider? The Communications Decency Act provides broad protections for these providers. And I guess it's obvious what the reason is behind this, because we value the right to communicate, and we don't want to put unnecessary burdens on that right, especially on these people who are only providing the platform and not providing the speech itself. States that no provider user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. So it's like I said before, the ISP is a platform, not a speaker. Just as if you wrote a defamatory statement about somebody and then passed it around a classroom, the piece of paper is the platform, and you can't sue the piece of paper. And generally that applies when the statements come from a third party. Some courts are starting to create some exceptions to these rules. Other actions involving online posts, emails, tweets, posts, and other online communications can also be the basis for a tort. They can also involve allegations of wrongful interference or infliction of emotional distress. So if you talk to judges who are over small claims or Georgia magistrate courts, they will tell you that there's been a large increase in the number of cases involving involving libel over social media in the last few years. Okay, the right to privacy, of course, is guaranteed by the Bill of Rights and some state constitutions. And major social media internet sites have been accused of violating some of these privacy rights. Okay, so the elements of this, we talked about this in intentional torts, is that people expect privacy when they enter personal financial information online. People also expect that online companies will follow their own privacy policies, and does the plaintiff has a reasonable expectation of privacy on social media. So I believe, if I understand it correctly, and again, this is not something that I've spent a lot of time on, and it's rather new, one of the concerns about Congress is how some of these social media platforms are using the information that they gather that is natural to the platform to make profits by selling that information to others. For example, what you might be interested in as a product, or what your political views may be, or whatever it might be. So it's sort of an invasion of your privacy by those platforms, and I think we can expect to see more discussion about limiting that ability. Retailers collect detailed information about consumers' behavior and preferences through cookies, and that's just a technical term for something that they have programmed into the computer to access that information. They're invisible files created to track a user's web browser activities. And they provide detailed information to marketers of individuals' online behavior and preferences, and that's then used to personalize online services. So if you keep getting these pop-up ads for something that you may have been looking for to buy online, it's probably because you were looking for something on a website that you had your cookies available through your computer, and that then spread out to various retailers or sellers who then can communicate with you through your computer to try and sell you something. So that's questionable as to whether or not that should be allowed, and whether or not such targeting advertising should be allowed. The Federal Trade Commission investigates complaints regarding privacy and violations. Due to the consumer complaints, the Federal Trade Commission forced many companies to enter into decrees that allowed the FTC broad powers to review their privacy and data practices. And anybody that violates that can be sued. Okay, so that completes this chapter. Again, this is probably one of the less important chapters because it's questionable whether it's really an area of law or an area of factual situations that fall into other areas of law, like intellectual property, torts, constitutional law, etc. Most of what we've talked about, we talked about in the other chapters. Okay, the magic word for this chapter, chapter 9, is spam. And that completes Chapter 9.